Recording in progress. Perfect. Younger, would you like to just check if your slides are working, and then I'll kick us off?
Yep, I think they are working.
Okay, perfect. Then you can switch them off again. And I'm glad to see you are the proper Younger. Good afternoon, everyone. My name is Marlies Richter. I'm speaking to you from Cape Town at the moment. And I have the pleasure of being the facilitator of this afternoon session that will focus on secrecy, accountability, and transparency. And our three speakers will talk about various strategies, creative strategies, to pressurize the state and the private sector to work within a rights-based framework. So we're going to hear about different perspectives and different ways of engaging on that topic. And we're looking especially at vaccine and health equity, and COVID medication. So welcome everyone, and thank you for the people who introduced themselves. It's much more cozy and personable to know who is in the room. I'm going to start us off with asking Slee if she will be the first speaker. Slee is an attorney of the High Court who works as an associate at Power Singh Incorporated, and she's an analyst at Alt Advisory. Her focus areas is public law, international law, and constitutional law, and she's got a particular interest in the protection of women and children and education policy in South Africa. Thank you, Slee. What I'm going to do is, you've got 15 minutes. I'll indicate like this if you have 5 minutes, and I'll indicate like this if you have 2 minutes. So please take it away.
Perfect. Thank you so much, Marlies. And hi to everyone on the call. It's such a privilege to be having these discussions with you in this particular space. And yeah, thank you for having me. So yeah, as mentioned, my name is Slindile Khumalo, and Marlies has already given background, so I won't repeat anything that's been already said. As a starting point, I must really commend the Health Justice Initiative's tireless efforts in promoting access to information, around vaccines. Since the outbreak of the pandemic, I have found the comprehensive timeline on HJI's site to be such a valuable resource in understanding key events which impact all of us really during this time. Marlies and others, I'm going to refer to two specific events which are particularly relevant to what I'm going to touch on this afternoon. So the first event took place in May 2020, when state leaders and health experts from the world over signed an open letter to call on governments to unite and get behind this idea of a people's vaccine. They were called to the United States in particular to waive international property rights and increase the ability of low and middle-income countries to inoculate their populations. Also, President Ramaphosa was one of the signatories, both in his capacity as president, of course, as well as chair of the African Union. Domestically, around the same time, we saw the establishment of the Solidarity Fund to provide relief where needed. And the second event took place in December 2020, where South Africa formally registered with the COVAX facility, which I'm sure everyone has heard of countless times already at this stage. But the gist of COVAX is to act as a mechanism which, bolsters vaccine equity and ensure a fair supply across the board. Really, the point of it was to level the playing field, as we're all aware on this call that a lack of access to healthcare services is a persisting socioeconomic issue globally. Despite numerous delays in the procurement of vaccines, what these two events highlight to us is that the South African government seemingly, from the very beginning, aligned itself with global efforts to ensure that vaccines are accessible to everyone in the country, regardless of the usual barriers which impede access to resources in South Africa. Earlier this year, We saw several announcements by the National Department of Health on the country's vaccine rollout strategy. And regrettably, there was some confusion around, several issues, including the contracting terms that South Africa had agreed to in order to procure vaccines, timeframes, plans to prioritize vulnerable communities such as undocumented migrants, refugees, and asylum seekers, whether these plans, if they existed, would be made publicly available, and whether there would be arrangements by the state to facilitate public engagement with members of the public, of course, civil society, and other interested stakeholders on the vaccine rollout strategy. Then came the litigation. So in January 2021, AfriForum and Solidarity launched an urgent application at the Pretoria High Court to obtain an order declaring the Department of Health's COVID-19 response document of 7 January 2021 to be unconstitutional and unlawful. Broadly, AfriForum and Solidarity were challenging national government's position as the sole procurer and distributor of vaccines. In their papers, the applicants contended that the exclusion of the private healthcare sector and the broader business sector was an unjustifiable limit on various constitutional rights. And the rights relied on in the application included the right to freedom of trade, occupation, and profession, which is enshrined in Section 22 of the Constitution, as well as, of course, the right to healthcare, which can be found in Section 27(1). Now, this application raised critical questions about the private sector, as well as private individuals who align themselves with particular ideologies and challenging decisions by government in a time of crisis, and the motivation behind these challenges, right? So Powerson Incorporated was instructed by the Health Justice Initiative to intervene in this matter as an amicus curiae, or a friend of the court, to make two very narrow submissions to guide the court in coming to a decision. So the first submission relates to the proper interpretation of the right to healthcare in the context of a pandemic where vaccine supplies are scarce. And the second submission related to the position taken in various foreign jurisdictions in support of state centralization in procuring vaccines. We included the expert evidence of Professor Leslie London, who is a public health specialist based at the University of Cape Town, the United Nations Special Rapporteur on the Right to Health, Dr. Tlaleng Mofokeng, as well as Professor Saad Omo, who is an epidemiologist based at Yale University in the States. When the proceedings were launched, I don't think it's controversial to say that the majority of us were anxious about, the delay in procuring and administering vaccines by our government. But really, as amicus, the gist of our first submission was that the principle of first come, first serve is not appropriate when allocating resources in a healthcare emergency, really. The World Health Organization has made it clear in its recommendations that the prioritization of vaccine access cannot be driven by market forces or economics. Further, the WHO placed an obligation on states to ensure that vulnerable groups who were at risk were the priority, not those who could afford to privately negotiate and secure vaccines for themselves, considering how limited the global supply was at that stage. And as we all know, Section 27 of the Constitution, as I mentioned earlier, imposes a positive obligation on the state to take reasonable and other measures, emphasis on other measures, and in our case, to, within its available resources, achieve the progressive realization of the right to healthcare services. Looking at it from a regional perspective, the African Union, in its own vaccine framework, highlighted the value of affirming the humanity of others during this time and upholding human dignity, which is something that just stuck with me personally. Our submissions in this case were not that private procurement in and of itself is inherently problematic, but that in the context of limited supply, private procurement without adherence to government strategy would likely lead to the constitutional violation or the violation of the constitutional rights of others. Simply put, it would further exacerbate inequality in our country and really lead to just an inconsistent allocation of vaccines. On the second submission, we set out how India, the United States, and the EU favored the strategy of state centralization. These jurisdictions acknowledged that limited supply meant private sector rollout to groups who did not necessarily need the vaccine as urgently as others was just not a feasible approach. Rather, what is necessary in these circumstances is a targeted, inclusive, and data-informed approach. Ultimately, the matter didn't proceed to hearing as the applicants withdrew. And the reason for the withdrawal was that the applicants contended that the state at the time admitted in its answering papers that there were no legal restrictions on the private sector to procure vaccines. Of particular concern was in relation to the conclusion or withdrawal of this matter was the way in which it was communicated to the public and the media. We do not believe that there was an accurate framing of the answering papers, and from our reading, what the state had highlighted was firstly that the applicants failed to include evidence showing that private parties had been precluded from securing vaccines. There were no attempts that had been made at this point by the private sector. And secondly, even if private parties had attempted to do so, it would be impractical for them as vaccine manufacturers were engaging solely with national governments. And this is really due to the extensive liability issues and concerns which go beyond the reach of private bodies and parties. So yeah, the matter was withdrawn, and this can be a somewhat frustrating aspect of litigation, is that cases aren't always seen right through to judgment, and parties are really deprived of the opportunity to ventilate their concerns properly before a court of law. However, when litigation isn't pursued, we can find great value in continued advocacy to hold the state and private parties or institutions accountable, and to also educate and mobilize communities. So public interest litigation is in many instances dependent on proper social mobilization and a common understanding of the issues at play. And sustained advocacy can lead to litigation at a later stage, where later or new issues come to light and we have more evidence to support our claims. For instance, now that vaccines are being rolled out nationally, the HAI has shifted its focus to access, government's contract with J&J, for example. And more broadly, we've seen the use of unconventional platforms such as TikTok to reach different audiences on vaccine education. We've seen the use of politicians and social media influencers recording their jabs, to boost public trust. So all in all, we all have a role to play in prioritizing the collective good over self-interest during this time, whether this is done through litigation or other more creative means. And as a legal practitioner, I'm very excited and committed to assessing, the different challenges that we may still face in this unfamiliar territory to ensure that nobody gets left behind as we navigate through this pandemic. Yeah, so that concludes my portion, but I'd be very interested to hear from speakers, what their thoughts on the litigation is, and just debate this further with everyone in the room. Thank you so much.
Thank you, Sleep. Would you prefer having questions now or at the end?
I suppose we can do it whenever. Should we maybe keep it at the end so everyone gets an opportunity to speak first? Thanks,
Lovely. Thank you, Sleep. That was excellent. We're going to move to Younger. Younger, if you can start sharing your slides, I will introduce you. Younger is a researcher at the Health Justice Initiative, and I'm working quite closely with her, and she's got a special interest in health economics and health technology assessment. And that is one of her passions, affordable life-saving health technologies. Younger, would you like to take it away?
Thank you, Marlies, for the introduction. Good afternoon, everyone. Thank you for joining us in this panel session, and I'll be taking you through some of the work that we as HJI have done to make sure that government provides us information to what is happening in the pandemic. Just to give you a brief introduction into who we are, HGI is a public health and a law initiative that focuses mostly on health equity and addressing the intersection between racial and gender inequality. So what we do, we address factors that influence inequity in health access, with a focus on medicine access during pandemics and beyond, focusing on race, class, and gender. Since its inception, HJI has been calling for equitable allocation of vaccines and transparency and accountable decision-making from our government. There's no secrecy in a pandemic. As a result, there is evidence-based policy information and transparent decision-making that are essential elements of a rigorous pandemic management. Also, openness creates an anxious public confidence in the measures that are imposed and also encourages active engagement with the evidence and reasons for such an imposition. Also, seeing argued in court in court that transparency is an element of a procedural fairness, and it's also a key condition for accountable decision-making and the promotion of public trust. Also, it is a constitutional duty on the state to ensure open and transparent decision-making. Also, providing access to information is a right that is enshrined in our Constitution, as Steve previously mentioned. Rigorous information dissemination and also the rationales for decision-making also set precedents for future pandemics and also national crisis management. As a result, as a result of not getting information from the government in the pandemic, HGI has made requests for information to the government on various issues. So we focused on the three main issues. That is, number one, the publication of vaccine contracts that were signed between government and the big pharma companies. Secondly, the publication of all MEG advisories on pandemic management. And thirdly, it is the vaccination of elite athletes before their age cohort. With regards to the vaccine contracts, HGI, we started engagement with the Department of Health to ask them to make public the vaccine contracts that they signed with Big Pharma around the 22nd of June. We asked for the voluntary disclosure of automatic and availability of all information that pertains to the government's response to the pandemic, and also all copies of all COVID-19 vaccine procurement and supply contracts. So the reason why we needed all of this information to be made public is because the pandemic is a matter of public interest and also warrants openness and accountability from the government. And also a state-led approach of information sharing is important. Big Pharma continued to insist on government signing NDAs, which would then prevent government from sharing the vaccine contracts. After engaging with the government on the 22nd of June, HGI did not receive any response. As a result, on the 20th of July, we filed a formal access to information request using the Promotion of Access to Information Act PAIA for the access to the vaccine contracts. On the 29th of July, the DG of Health informed us that they resolved to notify the vaccine manufacturers and distributors, and also to invite the vaccine manufacturers and distributors to make oral or written representation as to whether the request for access to information will be granted or refused. As a result of these, the Department of Health further requested additional time to communicate with the stakeholders involved. Whereas HGI responded on the 6th of August and granted the DG an extension until the 25th of August. However, from the 26th of August up until now, HGI has not received any response on the prior request for the vaccine contracts from the DG. And on the 15th of September, HGI filed an internal appeal using the PIA to the National Department of Health, and we informed the department that should the appeals not result in the disclosure of the vaccine contracts, HGI will be approaching a court of law for appropriate review. Up until now, today, there's been no response from the Department of Health, and the deadline for the internal appeal is set on the 15th of October, which is tomorrow. And then coming to the MEC advisories, we starting with the MEC advisories, right? So on the 30th of March 2020, the Minister of Health, Dr. Secrecy, established a COVID-19 MEC that consisted of approximately 51 world-class scientists to advise the Minister of Health on the pandemic. On the 14th of September, the minister also established another MEC, which is the MEC on coronavirus vaccine development. That's called the VMEC, that will advise him on all matters that pertain to the coronavirus development, the rollout, purchasing options, and the capacity to potentially manufacture vaccines locally in the future. Since inception, the MEC advisory on COVID-19 provided quite a large number of recommendations to the Minister of Health. However, these advisories were not published in the public domain initially, up until civil society and other organizations put pressure on the Department of Health to release these advisories. As a result, on the 20th of August, the department issued a statement indicating that the Minister of Health has decided that the MEC advisories will be published in the public domain. As a result, we've seen quite a number of MECs being uploaded onto the COVID-19 portal. And then on the 9th of August, on the 9th of March 2021, HGI wrote to the Department of Health and called for the publication of all outstanding advisories, because we had noted that quite a number of advisories were missing from the portal, and these needed to be published. However, after engaging with the Department of Health, there were still no substantive responses to our request, such that on the 20th of July, HGI filed a formal prior request and requested for the publication of all MEC advisories that we're focusing on the following main areas. For example, publication of all expert advice that the MEC committees receive on COVID-19, the prioritization and risk framework principles, and also the rationale as to why the AstraZeneca vaccine were sold or donated. Following our prior request on the 20th of July, we noted quite a number of other MEC advisories that were being uploaded onto the department's website within a week or so. Subsequently, we also noted that there was quite a long number of days that between when the MEC was issued and when the MEC was actually uploaded onto the website. But after the HGI prior request, we noted that there was actually quite a small number of days between the date of issue and the date of publication of the MEC advisories onto the website. As a result, as HGI noted, the acknowledgement of the publication of the additional maps, but we still noted that there was information that was not published in the public domain as per our initial pilot request. And then with regard to the Sisonke program, it's important to note that SAPRA approved the urgent study approval of the J&J vaccine for healthcare workers under the Sisonke program that was also held in conjunction with this SA Medical Research Council, right? And as a result, the Sisonke program started on the 17th of February, and it had intended to vaccinate approximately about 500,000 healthcare workers within 3 months. However, by the end of 3 months, only about more than 470,000 healthcare workers were vaccinated. And subsequently, we noted that quite a number of healthcare workers were not vaccinated in the Sisonke program before it ended. And also on the 17th of May, we had the national vaccine program commence. That meant people that were over 60 and older were getting their vaccine shots. Right. So note that the Sisonke program closed on the 17th of May, right? And there were healthcare workers that were not vaccinated. But between the 20th and 28th of May, we noted Springbok players, players, and Olympic and Paralympic athletes were being vaccinated. So that meant there were no healthcare workers, some healthcare workers were not prioritized, and the Medical Research Council, after the vaccination of the athletes, indicated that SAPRA made that they made urgent application to SAPRA requesting for the waiver to include persons of high priority into their study program. So they prioritized elite athletes into the study program before it concluded, because they said that there were vaccines that were due to expire. So as a result, HGI wrote to the Minister of Health and also SAPRA, the CEO of SAPRA, and the CEO of the Medical Research Council to request information about the prioritization of elite athletes under the Sisonke study. We did not receive any response, any substantive response into our request. As a result, between the 23rd and 28th of July, HGI filed a formal prior request to the Department of Health and the other secretary bodies for all copies and information that they received with regards to the prioritization of people other than healthcare workers. It's also important to note that we have filed, as HGI, we have filed quite several number of higher internal appeals on the issues that we've previously outlined. And we've informed the different stakeholders that should the appeals not result in the full disclosure of information, HGI will be approaching a court of law for appropriate relief. We've only received an acknowledgement for our internal appeal from the Department of Sports, Arts and Culture. The other stakeholders have not gotten back to us with substantive information on any of our requests. Just something to note on PIA. Is that the PIA is such that information needs to be disclosed unless it is exempt from disclosure, and in such circumstances where there are exemptions, this must be narrowly construed. And also, there's no discretion to withhold information that is not protected, and the unprotected material must be disclosed despite any other provision of PIA, unless it cannot be reasonably severed from the protected proportions. But we are saying that, just to conclude, pandemic transparency is important. We need to hold people accountable and also have a robust ecosystem of open decision making that are key elements to foster public trust and also build confidence in the public health measures that are necessary to contain the pandemic. And also, it is regrettable that as civil society, we had to resort to access of information, legislation to pressurize government and other bodies to release key information that relates to the management of COVID-19 in South Africa. It is also vital that a robust precedence of openness and engagement is established and maintained for future pandemics, because we will have in the future other pandemics that we'll need to deal with. And if we don't set precedents right now, we may find ourselves in a very scary situation that we might be able to deal with. Thank you so much.
Thank you very much, Younger, and also for staying on time. Our last speaker this afternoon is Tabitha Payne, who's a lawyer with Open Secrets. She's a Bertha Justice Fellow, and she's worked previously as a researcher and an analyst for over 10 years in the human rights field, which has included gender work, transformation in higher education, sexual and reproductive health rights, violence and crime, prisons and education law. Tabitha, over to you. Thank you very much.
Thank you, Marlies, and to the speakers as well. I think just to reflect briefly on what everybody has said so far is, I think one of the most challenging things about the pandemic has been the rapid way in which things just progress, and they progress without public engagement. We're the last to know generally, and that's after we have to push quite substantially. So take my hat off to you guys for getting the responses that you did. My take on today's discussion is slightly different. It's taking cognizance of the constitutional rights that have been impacted by the pandemic, as has been discussed as well. There's a range of rights that have been impacted, but the most obvious one is the right to health. And it's pretty clear that government has a whole range of obligations, but the more contentious aspect of it is, what are the obligations of companies, particularly in situations where we're talking about pandemics or natural disasters that are unfortunately most likely to still happen in our futures, and particularly in a society that's as unequal as we are. And I think that's also particularly demonstrated looking at pandemic-related things like access to PPE, such as masks, which are also legally mandated. So everybody has to actually walk around with a mask if they want to go into the public, go to the shops, buy food. These PPE equipment, all of this is manufactured and sold by companies. So there's this line, there's public-private sector line, but it's not as clear as I think we like to think about it sometimes. And there's actually quite a lot of blurring that happens. And it's particularly kind of stark when you look at PPE access. And how affordable it is, because people are having to buy masks. And when we saw the initial stages of the pandemic, we saw that what cost only a few weeks prior was around 10 Rand, now all of a sudden was 50 Rand, 80 Rand, becoming pretty prohibitive for a lot of people. And that's bad enough, but also the context of the pandemic created additional problems. People were struggling to have access to food because of, I think, if I remember correctly, during the first 2 weeks of lockdown, something like 1 million people lost their jobs, and this is in the formal and informal sector. but that got rid of access to food, never mind trying to buy a face mask. So we're talking about the basics here that are essentially being provided by the corporate sector. And that kind of brings me to the crux of the problem. What do we do about that? We're a civil society group, and we have to actually tackle these things and deal with them. And one of the more successful case studies that we can present is one that HGI and Open Secrets worked on, which was around PPE. And it started off actually as so it's around competition law and the Competition Commission. And the Competition Commission, we've been talking about access to information quite a bit. And it's very difficult for the public to actually access information that should be available. But there are bodies like the Competition Commission that are vested with powers to do precisely that. So they can request information and enforce that request, and in ways that are a lot more powerful and swifter. So in the initial stages of the pandemic, the Competition Commission in particular was very busy getting access to all of this information about what exactly the corporate sector was doing during the pandemic, and particularly in relation to price gouging. And price gouging is essentially excessive pricing on certain items that have to do with market dominance and power. I won't get into the technicalities unless someone has a question about it in particular. But it's essentially the Competition Commission investigated and appealed, launched an application to the Competition Tribunal against Dis-Chem for price gouging for masks. And they won in the Competition Tribunal. And then Dis-Chem appealed that decision to the Competition Appeal Court. It's at this point that Open Secrets and HGI came onto the scene, where we applied to intervene as amicus in that case. When we did, the Dis-Chem mysteriously dropped their application. But a small company called Babalegi, who manufactures industrial equipment, including dust masks, who had also been fined for the same wrongs of price gouging as Dis-Chem in the same circumstances. So they inflated their prices despite no cost increase during the pandemic, initial stages of the pandemic. They appealed their decision to the Competition Appeal Court. And so despite this being a very small company, the problem we were faced with is if they won on appeal, it would set a very bad and damaging and pretty scary precedent for the future. So that would include the COVID pandemic, but also any other pandemics or national disasters that happen in the future. So we decided to join as amici there as well. And that's basically Friends of the Court. I'm speaking mostly to those, but not entirely. So I think at this point also just to foreground the point of competition law, and in particular the Competition Commission. Competition law is an interesting aspect of law because it's essentially part of corporate law. It's at least seen that way, but fundamentally it is a rights-based or constitutional aspect of law. And for that reason, it can be used as a very interesting tool to advance constitutional rights. It also, because it's founded or based in kind of a corporate setting, it has an implicit recognition within it that companies affect people's human rights, and that therefore, by implication, they also have obligations to the society in which they function. Essentially, the case, Babalegi case, was about its ability. I mean, this is a technical aspect of it, but I'm a bit nerdy, so I like the technicalities, and think that they maybe either make the conversation more interesting or more boring, hopefully more interesting in this case. But Babalegi was able to sustain these markups that were unrelated to any cost increases by between 122% and 1,120%. So on average, they increased their prices by around 500%, which is no small percentage. And for this reason, as well as the increased demand by public, because people had to buy masks, and there was all of a sudden this huge, overwhelming demand, a population of 50 million needing masks, created what is called temporary market dominance, which means people had no choice. And therefore, the implications on human rights was even more exacerbated. And particularly in the context of COVID, where again, just to re-emphasize, people had to buy masks, and people did not have the spending power that they had pre-COVID, if they had any spending power. So for this reason, the Competition Appeal Court found in favor of the Competition Commission, and kind of incorporated our arguments within the judgment. Unfortunately, we weren't cited in the judgment, but yeah, we haven't been able to rectify that. Sometimes bureaucracy gets the better of us. But I think one of the things that is highlighted a lot in civil society, and this is I think my last point, is holding corporates accountable is incredibly difficult. Engaging with them is incredibly difficult. They don't respond well to civil society, and they most definitely do not provide information and answers that we should have access to. And part of this is, I think, people have an idea of the standards that the state has to people, and that's hard enough to enforce. But then it's a whole other ballgame when people are thinking about the standards that are required of companies to the people that they so fundamentally affect. And I think that most definitely needs to change. And the Competition Commission and competition law have been a very useful tool, and one that hopefully we can use more. It's a complicated beast, but if we learn it, we can master it. Babalegi is a good example of how to leverage these and other mechanisms to advance the public interest and protect the public. I think that's about all I wanted to say. I don't think I took up my 15 minutes. Hopefully there were tons of questions.
You have got 2 minutes spare, Tabitha. We're going to make sure that you make up for those 2 minutes with the questions that are going to come about the animal that is competition law. I'm going to just draw out some of the main points that I received from our speakers, and I want to thank them for really succinct and accessible presentations into what can be quite complex issues. Slee spoke about the case of solidarity in AfriForum, and highlighted the right to healthcare and the centralization of procurement of vaccines, and noted how public goods have to trump over self-interest, and that the allocation of resources within a pandemic has to be distributed equitably and equally, or more succinctly, equitably, and noted the importance of social mobilization in focusing the public's interest on these issues. Younger emphasized the significance of regular and thoughtful information dissemination by government, especially in a pandemic, and it's of particular importance when that information informs government decision-making, especially far-ranging government decisions, as we've seen in the pandemic around vaccines, the lockdown, and other policies that have gone to have affected everyone in South Africa in really large ways. I think the examples that Younger gave about relatively uncontroversial pieces of information that the public needs to make sure that government's decision making is transparent, and what barriers have been faced by civil society to ask for this information, and that this information is still not forthcoming. Tabitha rounded off the discussion, looking specifically at vigilance over profit making within a crisis, and the role of civil society and legal avenues available to challenge these. And I think there's a number of interesting areas that we can explore more. And what I'm going to do is to go to the chat box. Let me just check if we're in with the speakers, if they're all happy, if there's anything that came out for them that they might have forgotten in their presentations, if they can just give me a thumbs up if they're happy to take questions. Okay, I've got thumbs up from everyone. That's awesome. Let's go to the chat box and give people who've been jotting down questions in the chat box the first chance. Lisa asked about the engagement with the information regulator and whether that office has been helpful. And then we also have a question from Lisa to Tabitha, and the difficulties around competition law, and potentially how we could make better use of this area of competition law to advance social justice. Tabitha, I'm sure you'll be able to talk to that with great enthusiasm in relation to the work of Open Secrets and your previous engagement. There's also a question from Nasifa for Tabitha about the implications of these big price gouging of companies, and apart from the fine, how do civilians keep, or the public keep, these accountable? Then we've got Nicola asking, Slee, do you have a sense of how other private parties felt about the AfriForum application? Was there any outward support, I assume, from private parties towards AfriForum or Solidarity? I am going to give our panelists a chance to engage on these issues, and then I'm going to invite people to either continue using the chat box, or even more preferably that we hear your voice if you want to ask questions verbally. And I'll ask for people just to raise their hands after the speakers have given input if you have any comments to make or any questions. Slee, would you mind kicking us off with the Solidarity AfriForum answer or thoughts from you?
Sure, thank you so much, Marlies, and thank you, Nicola, for your question. It's a great one, and it's something I have looked into and reflected on quite a bit. Because everything happened so quickly in this application, and it was withdrawn at a relatively early stage, we didn't see any other parties who sought to join the application. And there was also really just no obvious parties that I suppose aligned themselves with the approach by AfriForum. What we did see is medical aid companies, for example, who expressed, an interest in assisting the government administer vaccines. But the argument there, or the position there, was different, because these schemes, these medical aid schemes, didn't necessarily want to act outside of government's plan already, whereas Solidarity and AfriForum were a little unclear about how they were going to prioritize the administration or administering of vaccines if they were able to buy them. So that would, of course, lead to huge problems if other private, the courts allowed private parties to procure vaccines, and all these different private bodies just took completely different approaches to how they were administered or sold and pricing and all that kind of thing. So yeah, we have looked into it. There was nothing very clear in terms of support for the application. I've also looked into, what AfriForum and Solidarity did after withdrawing, whether they attempted to procure vaccines. And there's been absolute silence in that regard as well, which, raises questions about what the point was of the application if they kind of took it nowhere after it was withdrawn. But yeah, it's a very good question, Nicola, and thank you for raising it.
Thank you, Slee and Nicola. I'm going to ask Yanga if she could address the issue of the information regulator. Yanga's having some connection problems in Durban and she's switched off her camera, but her voice will still be available. Yanga?
Thank you, Marlies, and thank you, Lisa, for the question. From our engagements, we engaged with the healthcare stakeholders that we mentioned, and we did not particularly speak to the information regulator at the time. Lisa, I hope that answers your question.
Thank you, Yanga. Tabitha, questions around the competition law, if you want to take that on.
Definitely. Thanks for the questions. So on the first question about the fact that competition law is not really well used, it's not utilized that much, and how to remedy it, as well as how to get to know the area of law a bit better, if I've interpreted the question correctly. So it is incredibly complicated. I remember when we first got the matter, I was just, I've read a little bit about competition law just because it's quite interesting. Again, nerd, but it is really, really complicated, particularly when you're looking at its movements during the pandemic. So the idea of temporary market dominance was a novel idea that was kind of spoken about in a Mail and Guardian article that made its way to the Competition Appeal Court, which also brings up the point. Writing op-eds is an important part of a civil society's function, just putting it out there. But there is, you learn as you go and as you use it. So don't, I guess, be afraid of using it. Just jump in there. But there are also opportunities. So Judge Dennis Davis, who headed up the appeal court, has recently retired, and I'm sure would be definitely interested in holding workshops and things like that on competition law and how to utilize it, so that kind of thing. But I think it's also it's a principled approach. So competition law is meant to be a transformative instrument, and I think if we have a good solid basis in constitutional law, then we can transfer those into competition law in a way. That's kind of how I've tried to understand competition law, at least. But yeah, and the Competition Commission, I think they're particularly keen on public engagement. They're very busy and they're very overwhelmed. They have a large sector to essentially investigate and regulate. So if civil society can help facilitate that, I think they'd be also keen. I'm not speaking for any of these people, but I imagine that they would be keen on workshops and the like. And I think civil society needs to come together and maybe try and do something like that. Then on the implications of price gouging. So other than a fine, I think the question's a very good one, because we often see companies fined, and the fine they get is usually a drop in the ocean to the profits they've made from the crime or the wrong that they've committed. Yeah, I mean, it's sometimes it's very funny because, well, very funny in a very sad way, but that's, for example, if you're regulating auditors, I think the maximum fine that URBA can impose is 200,000 Rand. The profits that they make, that auditors make of auditing companies and just not actually doing their job, is in the billions. So an administrative fine of 200,000 Rand is small change. So I agree, a fine isn't necessarily a solution. In the case of Babalegi, the fine wasn't very much, and in fact, it wasn't imposed in the appeal court, and that's something that we also didn't oppose, that the fine wouldn't be imposed. And the reason for that is that Babalegi it's a small company. It was very strange that this small company with an administrative fine of 76,000 Rand had 7 senior advocates representing it at the appeal court, which who knows how they got 7 senior advocates to represent them, but they did, and that's well beyond the administrative fine. But anyway, one of the solutions to this, though, is, I think, a push by civil society to move from administrative fines to fines that relate to profits. So it should be attached to the profits, not a thumbsuck exercise of what a judge, an individual judge, thinks a particular company should pay. Yeah, and serious damage can be done if you attach to profits. Yeah, and sorry, just a few more things. The other thing is shame the company. So Dis-Chem dropped out of its appeal, I think, because it was shamed. It knew that it would do an enormous amount of reputation damage to appeal a decision which was essentially about it inflating the costs for profit of something that people needed as a basic to go buy food or whatever. The other thing is to ensure that these things aren't done under confidentiality laws. So they aren't done behind closed doors in settlements and things like that. If we're going to hold companies to account, it has to be done in a transparent manner. That's also why, in terms of crimes, a little out of the competition law area, deferred prosecution agreements and things like that shouldn't be allowed. That essentially closes the door on truth. And lastly, demand more. Companies owe us as a society a lot of duties. If they're represented as partial people under the Constitution and under our laws, they must start acting like people.
Thank you, Tabitha. Are there any comments on the floor, from the floor, on any of the questions, and especially about how we can make competition law more accessible as a tool for social justice? Is there anyone else in the room, perhaps, who's got an experience or some thinking around the competition law? If you can put up your hand, that would be great. No keen thoughts on the animal that's competition law. We can have that percolate for a bit. Are there any other questions or comments following some of these issues around transparency and accountability that have been raised this afternoon? Yes, Lisa, please go ahead. And then Reese.
Thanks, Marlies, and for a great panel to all the speakers. I'm just continuing on the competition law train, and you know, obviously a kind of a big push at universities to encourage students who are interested in human rights and social justice to take subject and electives like like competition law. I think is part of the way forward. I know kind of when I was at university, I ran kicking and screaming in the opposite direction from anything that looked vaguely kind of economics or business related, and it's definitely a big regret that I've had since. But then, you know, in addition to that, I think we need to think about a little bit of kind of upskilling of our current cohort of human rights lawyers who are already practicing, which is why I loved your suggestion, Tabitha, about rounding up Dennis Davis, because obviously, you know, there's courses that people can do. Certainly WITS has kind of certificate courses through the Nelson Mandela Institute, but I think what would be most useful is if we could think through tailored training, so that it's not just like, you know, introduction to competition law, it's introduction to competition law and how it can be used to advance the public interest. Ideally all courses should be taught in that way, but often aren't. And so yeah, so just to kind of call to any of us here or our networks to kind of think through that. I mean, I think it applies to competition law in the context of this discussion around vaccines, but there might well be kind of other areas of traditionally private law that could be relevant. So yeah, just some thoughts. Thanks.
Thanks, Lisa. Those are great. Those are great points, and I think many of those lessons also apply on intellectual property. And at least when I was at law school, that was definitely something that I wasn't very interested in, and that human rights law and constitutional law were much more interesting. But especially in public health epidemics, we've seen what absolute importance there is on understanding intellectual property, and as with competition law, having ways of making inroads and understanding those issues. Tabitha, do you have any thoughts from Lisa's input?
Yeah, I love the idea. I think we must do it. We actually had an idea long ago, actually quite a long time ago, about 2 years ago now, actually, the time goes by, but around organizing some sort of workshop or at least a guide on public interest litigation, particularly with a corporate slant. So how to actually do it and utilize all the different areas, because one of the other things that's completely underutilized is the Companies Act. It contains a lot of provisions that have criminal ramifications, but we don't really use it. The PMFA as well, it has a whole bunch of conduct that's criminalized, but no one's really taken that forward or potentially explored it. So a creative public interest course would be really great, going beyond traditional human rights methods. One second into it.
Tabitha, could you just quickly tell us what PMVA stands for?
Sorry, PMFA. It's the Public Finance Management Act.
Okay.
Public Funds Management Act.
Okay.
I get my acronyms really confused. I got the acronym correct.
Yeah, I would certainly like a workshop on that one. Thanks, Tabitha. Reese, please tell us what you have on your mind.
Hi, good afternoon. Thank you so much for having us. I just want to say, Lisa, what you said, I resonate with completely. I'm currently a 4th year LLB student, and I completely, when I chose my modules, did not want to look at anything competition related because it's just too complicated. But my question is for Tabitha, speaking on those 2 cases that you spoke on, I think in the future, if we do have another pandemic or anything else like that, that these companies will probably do the same thing, right? Because we are in a capitalist society at the moment, which is everything is about making money. So finding these people is good and well, I agree with that. But is there not more tangible ways we can hold these companies accountable so that it shouldn't be like, oh, you did wrong, now we're going to punish you? How do we foster change within these big companies through either competition law or whatever the case may be? Thank you.
Thank you. Tabitha, do you want to take that and then over to Slee?
Sure. It's a big question and an incredibly important one. It's I think you're getting to the systemic change aspect of things. How do we make corporations not operate at the expense of people? And I think that's because of the kind of enormity of that problem. It has to be a multifaceted one, a solution that is. So I think it is using one of the biggest. I mean, when you talk to someone about corporate responsibility, it becomes a bit of a, you know, people say the new phrase is corporate social responsibility, and that has completely lost meaning. Everybody kind of rolls their eyes when they hear it, I think, nowadays. And they tend to do that. So they take something and make it meaningless, something that actually should have meaning. And I think the problem with that is that it's they turn responsibility into a marketing gimmick. And we've got to start saying that, changing that into actually you have the same obligations that we have to each other, you have to society. So kind of reframe it so that they stop being able to turn it into a marketing gimmick to actually make you consume more. But it's sorry, static happening. But yeah, that requires a range of different tools, including advocacy. And we often talk about advocacy, but its power cannot be understated. Legally, there's a whole range of things we can do, attacking the problem on a variety of levels.
Sorry, Tabitha, can you just pause? Mzwandile, could you please mute yourself? It sounds as if you are under the ocean. Mzwandile. Sorry, I just want to alert the moderator that we can put Mzwandile on mute. Mr. and Mrs. Moderator, would you mind switching Mzwandile on mute? Mzwandile, thank you, Mzwandile. Perfect. Please go ahead, Tabitha.
Yeah, so from a legal point of view, I think we need to approach it from all angles. It's part of the closing gaps. And this includes, it's a vast area. That's also, I think, why people are a little less familiar with it, is because it ranges from, competition law to beneficial ownership to, public procurement. It's just incredibly vast, the different levels and avenues that we have to actually tackle in order to stop corporate impunity. But if we galvanize enough of our civil society troops to do that, I'm sure we can close those gaps. There's lots of initiatives currently happening. So the current Companies Act Amendment Bill will create a beneficial ownership registry. What that's important for is the shelf companies that are essentially set up to launder money and do all sorts of things, as the latest leaks have shown us yet again. It's a multifaceted approach, though. I think that will win the day, using all of our tools, including legal.
Thank you, Tabitha. Slee, any thoughts?
Yeah, so I am not a competition law expert, and I won't hold myself to be one, but this just relates to, the point that Reese raised earlier, as well as Nazifa's question about how citizens could possibly play a role in keeping corporate accountable. And I think, there's been different views and debates around whether corporates have, what responsibility they have in terms of profiting during, such a time. I think at the very minimum, we can try and hold corporate to account to stick to a principle of not of no harm, really, of not creating harm at the very least. And that obviously will take a huge amount of mobilization. And as Tabitha said, just galvanizing people and consumers we want corporates at the very least to not commit harm during such times of emergency. Yeah, and it will be interesting to see, or distinguish rather between, sincere attempts and commitments to do so, and, distinguishing that from these gimmick marketing tactics that we see very often, as Tabitha alluded to. But that's also something just to consider, to demand more as consumers and support corporates that see their social responsibility during such times. Yeah, that was my comment.
Thank you, Slee. Nicola, I see that you've added a number of things at the chat. Would you like to talk us through it?
Sure. I was just saying this conversation's got me really interested in thinking more about the different strategies needed when, advocating against a private company or companies versus against the state. And I think a lot of, even what we've heard this during this meeting, this gathering, but just in general, the cases we read in law school, it's often challenging the state. And so I was just saying, maybe those holding mining companies accountable, but also now in this case, these cases that we've heard about in this panel, there's advocating against the state. So I mean against private companies. So I wanted to know if any of the panelists have any more thoughts. I know we've got some, but any more thoughts on the different approaches when you now are either litigating or advocating against a company instead of the state? Thank you.
Tabitha, Slee, Younger, any other thoughts around this topic? Yes, Tabitha, go ahead.
I mean, I don't have more thoughts really than what I have already said. But I think that we need to be a bit braver, and part of that is obviously when you're litigating against a company, one of the biggest fears that you're going to face is an adverse costs order, because you're not protected by the usual public interest principles. So that would be buyer watch and things like that. So there's kind of legal hurdles that we've got to attempt to close before we can really fearlessly hold corporates to account. But one of the ways that we can do it in the meantime is through regulation. So that would be when a law is being changed, particularly that impacts the private sector, don't look away, engage with it and make submissions. The other thing is make the regulators better. So demand more of them, and they do their jobs more, not anymore, but also in a transparent and publicly accessible way. The regulators are regulating in our interest, and so we're allowed to see what they do or do not do, and also engage them on what is happening. Too often the regulators do that behind closed doors in conversation with the companies that they're regulating. That's for so many obvious reasons unacceptable, but it's the general practice. The other aspect of it is appointments. So we need to engage more on who's appointed to positions of influence. So that would be who's appointed to regulatory positions. We have a say. We should have a say. Just like when the Chief Justice is appointed, we have our say. We should have a say about the other regulators that are regulating in our interest and making decisions that fundamentally impact us. The last thing I would say is, and it's just slipped my mind. I'll leave it at those.
Thanks, Tabitha. Younger, I see you have your hand up.
Yes, I would just like to add on to the few points that Tabitha has mentioned. So we could also use the PIRE Act even more than just using it to gain information from public sector, but also the PIRE Act allows us to also seek information to private companies, regardless of whether they're in health, mining, or pharma, or wherever. So if we can, as as civil society or as individuals use the PIRE Act against the company that we feel is not being transparent with information, and pursue the PIRE and take it as far as we possibly can. Yeah, I think that's my point there.
Thank you, Yanga. Lisa, please go ahead. I see you've also got a chat in the comment in the chat.
Thanks, Marlies. One of the things I just wanted to flag, everyone on this call might be aware of it, but there is a collective called the PIRE Civil Society Network, which is a group of organizations who use PIRE quite regularly and routinely struggle with it, but continue nevertheless. And a couple of years back, that group started collating a collective data set of what the trends were in relation to PIRE use. And I think some of that was in response to the report that the Human Rights Commission used to produce of kind of this, how well PIRE was going. And at least a long time, a while back when it started, there was a concern that it was reflecting a much rosier picture than was actually the case for civil society organizations. And so there's been the shadow report that's been produced more or less annually. And so, you know, I think you guys have, HDI has obviously been doing such important work on PIRE. So if you're not connected into that network yet, I'll post some contact details in the chat, because it would be so useful to kind of harness your experiences of using PIRE, the good, the bad, the ugly, just to kind of add to that collective repository of knowledge about it as well.
Thank you, Lisa. And it would be great if you could pop the details in the chat box, so that we can all go and look at that. Yanga, do you have any response to that?
Yes, Lisa. We did have a look at the latest ATA shadow report that was published. I think it was 2018. It shows a good reflection of how PIRE has been used to access information from public and private sector. Public sector has been responsive with providing information as per the request of civil society or individuals in the past, and the report has shown that most of the PIRE requests, they do get responded to, but then there are some that don't even get responded to or even get acknowledged.
Nice. Thank you, Yanga. I'm just going to quickly address a comment that Lisa put in the chat box around the engagement by especially the Treatment Action Campaign and the AIDS Law Project in the early 2000s on issues of competition law and intellectual property, for greater access to antiretroviral treatment. And I think there are a number of lessons to be learned, and for some of the COVID-19 activism that's happened. You might recall that the competition law was used in challenging GlaxoSmithKline and Boehringer Ingelheim, especially for exploiting their market dominance and excessive pricing in antiretrovirals. That eventually led to a settlement in 2003. These organizations also challenged state-sponsored AIDS denialism through using especially constitutional arguments. And then, yes, of course, on the international law sphere, influencing the Doha Declaration, which has to do with the World Trade Organization, and the TRIPS agreement, the TRIPS waiver, which a lot of advocacy efforts are going into at the moment to get the World Trade Organization and the member states to agree to having some flexibilities in patents. So I think there's a lot of rich discussion that we could have around that, perhaps for another forum. I see the chat box is lighting up, and I see there were some comments about slap suits. Let me see. Chuku, were you the person about the slap suit? So Kudu, do you want to just talk us through your comment?
No, I wasn't. I hadn't mentioned the slap suits.
Okay, you mentioned what you wanted to mention. Sorry.
Something else.
Yes, go ahead.
So, oh, okay, cool. Thanks. So I don't know if I can say anything much apart from what I wrote there, but basically, what I was basically thinking about was like the theme that I picked up was that, you know, there isn't enough that's being done to hold corporates accountable for, or there aren't strong accountability measures for, you know, the conduct of corporates and the impact that some of the work that they are doing is having on citizens. And I guess the thing that I thought would be worth thinking about is because there's a general perception that the punitive measures in place, the punitive measures that are set out in legislation aren't sufficient. Maybe that is something worth looking at. You know, should there be stronger punitive measures? Should there be much higher fines? Or should civil society organizations call for piercing of the veil and hold directors, you know, directly accountable for, you know, for actions? So that's a little bit of a flapped version of what I wrote there, but yeah. No, thanks.
That was great. Thank you, Tukudu. Slee, I see it was you and Nicola who were talking about slap suits. Do you want to tell us what your thinking was?
Yeah, sure. I mean, doesn't go beyond my message as well. It was just raising the point that, you know, as jurisprudence develops, you know, in years to come, I think the main slap suit or the only slap suit judgment that we have so far in South Africa was the one handed down by Judge Goliath earlier this year. And just, you know, if our judiciary and other actors can take, you know, more clear stances and recognize this kind of intimidatory behavior, then civil society and the public will hopefully feel safer, you know, in taking on these powerful entities with very strong and solid legal teams. So that's just something to look out for as well. Yeah.
Thanks, Lee, and thanks to Kudu. I recognize that there's 5 or 8 more minutes left before it's time for tea and the wrap-up plenary. I want to give a last chance for any comments or questions. Okay, I can see everyone is keen for their mid-afternoon cup of tea. I'm going to close the session and to thank our panelists, but especially our audience for the really rich engagement. It certainly had me thinking a lot. One of my key takeaways was this really interesting discussion around some of the neglected areas of law, like competition law, the Companies Act, in perhaps intellectual property and PIA, which we spoke about a little bit, the Public Finance Management Act, Tabitha, which I quickly looked up on the internet so that I have the right acronym. How there's a need, especially for human rights and social justice activists, to be more au fait with some of this legislation. And I'd see there was a lot of support for the idea of having a workshop or being able to break down some of these complex technical pieces of legislation and to see how we might be able to use those for human rights and social justice work. I want to say thank you again to panelists, to everyone, and to note that the session has been recorded. We'll make some of the slides available, and to encourage people to please join up again at 3:30 for the concluding plenary that will look at donors. We know money makes the world go round, and that that you have your cup of tea before you join. Thank you very much, everyone, and have a good afternoon.